you're all very welcome to this Law Society Practice Information Session. I'm joined today by Simon Treanor from the Legal Services Regulation Executive at the Law Society of Ireland, and he's going to be discussing partnership agreements and succeeding practice rules. So if anyone has a question, we'll take it on the chat, but over to you, Simon.
Thanks, Justin. Appreciate it. You're all very welcome. And I suppose to start with, put simply, to define a partnership, the Partnerships Act 1890 states that a partnership is the relationship which subsists between persons carrying on a business in common with a view of profit. And while it's clear under the Partnerships Act 1890 that a company can be a member of a partnership, for the purposes of the Solicitors Acts 1954 to 2015, this is impermissible, as it would breach Section 64 of the Solicitors Act 1954. And Section 64 prohibits a body corporate to do any act as to imply that the body corporate is qualified or recognised by law to act as a solicitor. And the reason I mention that is it's a query that often arises from English and Welsh solicitors seeking to commence a firm here. As you may be aware, the structure of an LLP in England and Wales is a corporate body, whereas in Ireland it remains a partnership. So the partners in a solicitor firm must be practicing solicitors, and those persons who hold themselves out to be partners in the firm must hold a practicing certificate for the entire time that they are a partner. And that includes any time taken off for maternity leave, paternity leave, or career breaks. If they're held out as a partner, they must hold a practicing certificate. Unlike companies, partnerships don't have a separate legal personality, and this means that a partnership can be sued in the firm name or in the name of the individual partners. And while I've mentioned that partnership agreements strictly aren't a matter for regulation because these are private contracts between solicitor partners, occasionally we get disputes arise in terms of partnership agreements, and solicitors ask for the society to intervene. But that's not a matter that the regulation department can deal with. I would mention that the issue of salaried and equity partners commonly arises, and a practice note was published by the Registrar of Solicitors this year in April, setting out the position that both salaried and equity partners have joint and several liability for the firm in terms of regulation. Now, this position isn't new, and it's merely setting out and writing the Society's long-held view on the matter. Holding out as
a quick question on that. Sorry, is a salary partner part of the part? Should they be part of the partnership agreement?
They may be in certain circumstances, but often they're kept as a salaried partner, whereas an equity partner would have to pay their own personal taxes. The salaried partner would usually come under the PAYE system.
But that doesn't excuse them from the limited liability.
No, that's for the purposes of regulation. They are responsible for the firm. So the Partnership Act 1890 confirms the general principle that a partner is an agent of a firm and of the other partners for the purposes of the business of the partnership. So consequently, a partner is an agent for the firm and all the partners in the partnership business. Maybe to put it in a more simple and familiar terms, as Alexandre Dumas put it, all for one and one for all. Now, the Society actually does hold a draft partnership agreement, and this can be found on the website or by maybe perhaps contacting Justin here, who'll kindly assist you. And it's a draft agreement which you could augment and amend for your particular requirements. While the partnership can exist without a formal agreement, it'd be foolhardy to do so due to the number of matters that can actually go wrong. And it's suggested before entering partnership, ensure a good, well-drafted agreement is put in place to address the many issues that are likely to arise over the course of the agreement. It could be wise to have another solicitor colleague have a look over the draft agreement prior to endorsing it. Now, the obvious things that enter for a partnership agreement include the firm name, the nature of the business, the premises from which the business will conduct its affairs. And I would bear in mind that Regulation 4 of the Solicitor's Practice, Conduct and Discipline Regulations 1996 applies to solicitor firms, which means that the name of the firm should be current or former partner or principals, or any other name that's given written authorization by the Law Society. However, for our purposes here today, and drawing on some of the experience I've had over the years, it seems more prudent in this session to focus on the more contentious matters that are likely to cause disputes in partnerships. And the first thing I will draw your attention to is the decision making and voting rights. So the partnership agreement should really make clear how decisions in the partnership are made and whether there are any weighted voting rights or whether all votes are held equal. It should be clear whether there is permission for a proxy to attend the meeting and vote for an absent partner. And you should make sure, of course, that a written record of all decisions is taken. In terms of decision made, should all decisions be made by simple majority of voting members, or will there be maybe special resolutions which require 75%, perhaps 100% majority to pass? In certain circumstances, there should be some voting restrictions, and that would include circumstances where there's a resolution to require a partner to retire. That is to say, maybe a compulsory retirement, provided there is provision made for that in the partnership agreement to be invoked. Another example would be where the partners are seeking to suspend one partner. And again, this is the kind of thing that there should be provision for made in the agreement. Second thing that actually would be important to note in the partnership agreement is, of course, profit sharing. Of course, nothing is going to cause money or tension as quickly as the division of monies. I'd recommend a great deal of thought is put into this before endorsing the partnership agreement itself. So first of all, you should decide how the profits are to be divided. Are all partners going to take an equal share of the profits? Are there going to be bonuses paid for exceptional performance? In certain circumstances, some partnerships, they would give the managing partner an additional share of the profits, as they may undertake more administrative matters rather than the provision of the core legal services provided by the partnership. And when contemplating the division of profits, is it going to be done on an annual basis, perhaps a monthly basis, or a quarterly basis? And it could also be the profit sharing is done on the basis of fees earned by each partner, the eat what you kill principle. Provision can also be made for how to divide the profits where there's a retiring partner or a partner who leaves the partnership for any other reason. And one more matter that occurs is where profit sharing is concerned. There should be thought put into where there are periods of absence. And for this purpose, I'm talking about periods outside of the normal annual leave. So that could include maternity leave, paternity leave, force majeure, and sometimes where illness or incapacity matters arise. Provision should also be made for unauthorized absences from the business of the partnership and how those things should be dealt with. And a third thing that comes to mind in terms of a partnership agreement are day-to-day responsibilities. Now, while the partnership agreement itself is going to divide for a solicitor firm maybe into sections dealing with litigation, probate, taxation matters perhaps, but they need to consider other matters beyond the provision of the core legal services themselves. And that can include responsibilities in relation to human resources, compliance with AML obligations, risk management, professional indemnity insurance, and even maybe fire safety. It should also be made clear who is the compliance partner for the purposes of the solicitor's accounts regulations. And fourth thing that occurs to me in terms of partnership agreements is retirement matters. And it's entirely a matter for the agreeing partners to determine whether there's going to be a mandatory retirement age from the partnership. And this is often put into partnership agreements, usually in around 60, sometimes 70 years of age. Where firms sometimes wish to retain their talent, often former partners are retained on a consultancy basis, perhaps to work on individual matters or files. And again, provision can be made for this within the partnership agreement itself. However, there could be also provision made for compulsory retirement for non-performance, where a partner has been unable to substantially perform their duties as a partner, which could be by way of illness, perhaps injury, or any other possible cause. Again, the details of this and from when the compulsory retirement date takes effect should be detailed within the agreement. And a further matter in terms of retirement that comes to mind is retirement compulsory on notice. And this could arise where some of the partners believe that the retirement of another partner would serve the best interests of the partnership itself. Essentially, this would arise in terms of underperformance by a particular partner. Another matter that comes to mind in relation to partnership agreements includes force majeure. While nobody really wants to think about the possibility of incapacity of death, it would be wise to make provision for circumstances that unfortunately do arise. People get incapacitated for various reasons, and it would be best to address this possibility in the course of the partnership agreement. A further matter that arises is the possibility of suspension or expulsion from a partnership. And it would be prudent to consider circumstances where it would be appropriate to suspend or expel a partner from the partnership. This can arise in terms of obvious matters, whereas a partner may have their practicing certificate suspended by the High Court, or where they're struck off the role of solicitors. But other things that could impact this include where a partner is convicted maybe of an indictable offence. One of the final things I would say in terms of partnership agreements is, and is one of the more important things, is to include provision for dispute resolution. And this is one of the more important things that should be clarified from the very beginning. It should be clear whether any disputes go straight to mediation, and if mediation is not suitable, perhaps the matter could go to arbitration, and how those matters should proceed should be set out. So those are some of the more pertinent provisions that I would say should be considered when entering into a partnership agreement. However, I definitely recommend reviewing the draft agreement available on the Society's website, as it provides a great deal of detail and is a useful starting point when considering partnership. And over the course of the last number of years, there's been a notable change in the legal market since 2019 with the introduction of LLPs. A number of firms have now changed their structure to take advantage of these provisions in order to limit their liability, which is understandable. And it's in the context of these changes that some sole practitioners and sole principal practitioners may wish to consider changing their firm structure to a partnership and subsequently then to an LLP. Where they're doing so, they need to be cognizant of the succeeding practice rules, which I'm going to discuss now. And where a solicitor firm ceases, the files must remain covered by a policy of professional indemnity insurance. And there are only two ways in which files from a ceased solicitor's firm may be covered by professional indemnity insurance. And those are through the runoff fund or through a succeeding practice. And it's kind of difficult to separate the two topics of the runoff fund and succeeding practices. They are very much interlinked, but the main thrust of this will concern succeeding practices themselves. So the succeeding practice rules in the runoff fund were put in place to prevent a situation whereby client files were left uncovered by a policy of professional indemnity insurance. Previously, solicitors were required to purchase their own runoff cover, and this made retirement an expensive proposition. It also meant some solicitor firms did not put the requisite cover in place, and that left some clients without recourse. The rationale for maintaining the succeeding practice rules is to minimize the application of the runoff cover provisions. So professional indemnity insurance is done on a claims made and notified basis. And this means that the policy of professional indemnity insurance that will meet a claim is the insurance policy in place at the time the claim is made and notified to the insurer, and not necessarily the policy of professional indemnity insurance that was in place at the time of the alleged negligence occurred. Under the succeeding practice rule, the insurer of the succeeding practice takes responsibility for claims arising from the acquired firm. The current definition of what constitutes a succeeding practice can be found in the Solicitor's Professional Indemnity Insurance Amendment Regulations 2022, and it includes a firm that is held out as being a succeeding practice to a previous firm, or where a firm is conducted by a partnership where two or more of the previous principals are identical to those persons who are principals of the previous partnership. It can be where a sole practitioner who was the sole practitioner of a preceding practice. It can be where it is conducted by a sole practitioner who is one of the principals conducting the preceding practice. It can also be where it's conducted by a partnership in which the sole practitioner conducting the preceding practice is a partner, and where no other person has been held out as a successor to the preceding practice. Or it can be where the partnership or the sole practitioner who conducts the practice has assumed the liabilities of the preceding practice. These are set out in the 2022 regulations, and it's worth having a look at these to understand them better. Therefore, a solicitor firm that becomes a succeeding practice to a firm that has ceased takes on the files and the liabilities on those files from a specified date. And what this means is that if a firm becomes a succeeding practice on the 1st of September 2023, and a claim arises in respect to the preceding firm from maybe January 2023, the PII policy of the succeeding practice is the one liable to meet that claim. This means that there's a continuous policy of professional indemnity insurance in place, and there's no gaps in the cover. A succeeding practice can occur amongst other circumstances where a sole principal decides to change structure to a partnership. Their new firm will fall into the succeeding practice rule. It can also occur where a firm is expressly held out as being a succeeding practice. So where you see a firm saying, perhaps incorporating the firm of O'Brien Solicitors, for example, it'd be usually where one firm acquires the other. And it should also be noted, in some circumstances, there can be multiple succeeding practices. Now, this may arise in circumstances where perhaps two sole practitioners dissolve their respective firms and go into partnership together. It could also arise in circumstances where four partnership firm dissolve and two partners go into one partnership and the other two partners go into another. So there'd be multiple succeeding practices in there. It's worth thinking about, if you want to avoid being held out as a succeeding practice, there are ways to do this. And in simple terms, I suppose, if none of the specified conditions that are set out in the 2022 regulations apply, then the firm is not a succeeding practice. If another firm is or was held out as a succeeding practice, then the firm is not a succeeding practice. And if a firm enters the runoff fund and passes its file on to another firm which does not hold itself out as a succeeding practice, then no succeeding practice arises. So in order to avoid being considered a succeeding practice, don't include any reference to the ceased practice on your firm's stationery. Don't advertise the fact that your firm has taken on the business of a ceased firm. Don't lead clients of the ceased firm to believe that your firm is a continuation of the ceased firm itself. And despite being desirable in business development terms, don't use the name of the ceased firm for any promotional or other purposes. So it's clear from this that the determination of whether a firm will be a succeeding practice really depends on the particular circumstances arising. And while the society will seek to assist firms in determining, on the particular facts provided, whether a particular firm may be considered a succeeding practice for the purpose of the regulations, the society cannot and will not provide any declaration or ruling to that effect. The society always considers that it's best practice for the relevant firm to liaise with their broker and/or the insurer with a view to ascertaining their views on whether the firm would be considered a succeeding practice, and to discuss generally the impact on its professional indemnity insurance going forward. And while of course it's desirable for clients of a ceased firm to become your client, it must always be recognized that the client file belongs to the client. They can't be coerced into authorizing your firm to act for them. So it's highly recommended, before you consider becoming a succeeding practice, you conduct your due diligence on the firm's files, maybe check their accountants' reports, check the outcome of any law society investigations that took place, and certainly review any claims made on the policy of professional indemnity insurance. Taking the time to conduct these searches will give you a good indication of the type of firm you're dealing with and whether it's desirable for your firm to become a succeeding practice to that firm. And it would be, I suppose it's important when speaking about succeeding practices to mention briefly a Phoenix firm. And a Phoenix firm is any firm that has entered the runoff fund that, in the opinion of the Professional Indemnity Insurance Committee, is largely similar to, or is a succeeding practice to, a predecessor firm. So a firm can't enter the runoff fund for the purposes of dumping claims and then recommencing a new firm with a clean claims history. It's designed to prevent the abuse of the runoff fund. And a firm entering the runoff fund has to sign a declaration stating that they've no intention of forming a new firm and confirming that all claims have been made and notified up to the expiry date of the insurance. If at a future point in time, the solicitor commences a new firm, the society runs what we call a Phoenix capture system. And this identifies any possible attempts to open a new practice. This will be then escalated to the PII committee, who have the authority to declare a firm to be a Phoenix firm, if that is the case. If they do so, the new firm will then have to get succeeding practice cover in order to commence in practice. They'll also have to cover the cost of any validated claims made on the runoff fund at that time. If the firm is declared a Phoenix firm and doesn't get the requisite insurance, they won't be permitted to commence in practice. And I think that's just coming up to enough time, Justin, to get through everything. And I'd like to thank you very much for roping me into one of your sessions again. And I'm happy to take any questions in relation to those matters, if you like.
Yeah, well, there is a question. There's what will happen if one of the persons in a two-person LLP dies? Must the LLP cease immediately, or is there time permitted for the surviving partner to regularize matters and have a new partner join the practice?
Well, an LLP is defined under the Legal Services Regulation Act as being a partnership, and the partnership would cease on the death of the partner. So I think the firm would have to restructure as a sole practitioner partnership, or have to recommence as a different partnership because the partnership would have come to an end. And you would not only need to notify the law society, you would also need to notify the LSRA in relation to a change in that partnership as well, or a cessation in that case.
And just while you're on that point, that notification of the LSRA, when we put up some link to finding out more about LLPs, but you must notify both the law society and the LSRA when you're forming a new partnership, or if there's any changes to those partnerships. Is that correct?
That's correct, Justin. So if you are commencing a new partnership, you need to commence the new partnership through the Law Society of Ireland, and with the commencement and practice form, the professional indemnity insurance, the headed note paper. Of course, you can contact firms@lawsociety.ie and we will assist you with that. And once the society has gotten the new firm commenced and you've been issued with a new firm number, then they can approach the LSRA for the purposes of seeking authorization for that firm to operate as an LLP.
Yeah, and that link provides on the LSRA website provides all the detail around how you might do that, etc.
Indeed, and there's a booklet there as well on the LSRA website that's very helpful as well.
So another question there was, are firms who take over all files with consent of the Law Society from a struck-off sole practitioner deemed to be a successor firm?
Usually where a solicitor is this would usually arise, and I'm making certain assumptions in this particular question, Justin. Usually where a solicitor who is in practice is struck off the roll, one of the orders the society would seek is to take up all the files and documents, etc., from that solicitor firm. So usually the practice closure section would take those files up in those circumstances in my experience. So I don't think something like that would arise, but I'm open for somebody to send in a more detailed question to me about it if they like. There's no trouble.
And where might they send that, Simon? Is that firms@lawsociety.ie? Is that the best place?
You can send it to my personal email address here. It's s.treanor@lawsociety.ie. And I'd be happy to look at any query like that. But as I say, my experience when a practicing solicitor is struck off the roll, the society generally seeks the take up of all files and documents from that firm.
Okay, well, if there's no, we just have another minute or two, but if anyone had a further question, we'd take it on the chat. But other than that, Simon, thank you very much for giving us your some clarity to what sometimes can be an area that's not entirely clear for everybody. I suppose on the 4th of October, just to give everyone a reminder, we're having an information session on remote witnessing of deeds and legal documents with Rory O'Donnell. And then on the 11th of October, we have a cyber security review with Tanya Muller from the Technology Committee. So, well, thanks everyone for joining us today, and we'll talk to you on the 4th of October. So, slán agus gur mágat.